Hi, it's Mike DelSignore. In this video, I want to talk about what you need to know if you took a breath test in the case. Can you still win the case? The answer is yes. I win cases all the time with breath test evidence. And it's not an insurmountable obstacle. It does make the case more difficult to prove. Not every breath test case can we get the breath test thrown out of evidence, or can we convince a judge or jury not to consider it. But these aren't, I think, far too often people admit to these cases when, with a little more effort, a little more work, you may have had a better result. So first things first, when you take a breath test, it's over 0.08, you can get your license back within 30 days. So while the case is pending, you can be driving, which can be a major advantage. Sometimes people refuse a breath test, can't go the period of time, which is typically 6 months, without driving. So when you take it, you'll be able to function better, have your license back, go to work, full license back, not a hardship license. Let's say this is a case where we don't want to fight the case. Let's say not only do you have a high breath test, but the observations are otherwise strong. If you go to court within that 30-day window, the 30-day suspension ends and the 45-day suspension starts. So if it is a case that ultimately can't be won, it benefits you to make a quick decision, get back to court, and save a little bit of time on the suspension. But in today's video, I want to talk about the breath test case that we're going to fight. We're going to try to get the test knocked out of evidence. And why do we do this? So we're only going to do it if it makes sense. So there's two ways the government can prove an OUI case. One, based on the observation. So the officer can get up there, which they do all the time in cases with no breath test, and say, hey, I pulled this guy over, or woman over. They're all over the road. They're driving erratically. I came up to the window. I smelled alcohol. Their speech was slurred. Their eyes were bloodshot and glassy. I asked them to get out of the car. They were unsteady on their feet. I asked them to do field sobriety tests. They couldn't do those tests correctly. And based on that, I formed the opinion that they were impaired. Now, that's a very subjective case. And in many cases, you'll be found not guilty because it's too subjective to say someone's under the influence beyond a reasonable doubt. But it's possible a judge or jury can say, depending on the opinion, and that there could be video, there could be other evidence, there might be other testimony, that's enough to say you were under the influence. So all they have to do is prove alcohol diminished your ability to drive safely, and it can be done with testimony. Some people think, oh, it's just hearsay from the officer or just the officer's opinion, but every day in court, if a witness gets on the stand and says something happened, that's enough to convict somebody of a crime. It has to be believed. It has to be believed beyond a reasonable doubt. But the officer's opinion would be enough evidence, and it happens in OUI cases all the time. So let's say we think that the observations of the officer are not going to be enough for a guilty verdict at trial, but there's a breath test. And I have a case like this in in a few of my other courts, but right now I have one particularly in Rentham where it's a really good case. Client probably found not guilty without the breath test. So what we're going to do is we're going to try to get the breath test knocked out of evidence, and there's a lot of different ways to do that. At trial, the officers have to testify to certain procedures they followed to admit the test into evidence. Other officers have to come in and discuss the certification, the testing of the machine to show that it complies with an annual certification, periodic test requirement. And they're going to show that this test is accurate and reliable. Sometimes in cases, we can show that, hey, our person didn't consent. Without an actual consent, the test could get excluded. In other cases, you might have a medical issue that explains why the test could be over the limit. So in these kind of cases, there are different ways to contest the breath test. We can put it on for a motion prior to trial to exclude the test. Sometimes I'll just put it on for trial, and I'll see if the government can get the test into evidence. We can do it with a judge or jury. I have done bench trials with breath test cases where I've gotten the judge to exclude the results or find them not accurate and still find the client not guilty on the impairment theory. So think of it as just one piece of evidence. Don't think of it as insurmountable evidence. We weren't using these tests for about 7 years. So if you had a breath test prior to August 19th, 2019, and if you admit it to any case, it can be reopened. But these tests weren't used because of problems with the machine. So don't assume that the breath test is accurate. There's different ways that it may not be accurate. It makes assumptions about the person. It assumes we all have the same breath to blood partition ratio. It assumes your body temperature is a certain temperature. So basically it takes, it makes some averages and it comes up with a blood test. But how does it come up with a blood test? When you're blowing into a breath test machine, it makes assumptions because it makes a conversion from breath to blood. It makes different assumptions based on temperature. It relies on a scientific theory called Henry's law. So there's a lot going on here, a lot of assumptions, a lot of science that may not be accurate in your case. So don't assume that you can't win these cases. Consider fighting the cases. Consider what can be done. Sometimes a motion, if we file a motion to suppress, we might be able to find that a legal issue prevents the breath test from coming into evidence or prevents the government from testifying even about the stop if you were seized illegally. So call, text anytime. My passion is helping people charged with OUI cases. Been doing this for years. I study breath testing almost daily. I go to seminars. I spend my own money, travel all across the country. I teach other attorneys how to challenge breath tests here in Massachusetts. And I'll be happy to help you explain my thoughts on the case and help you make the best decision possible. Call, text anytime, 781-686-5924.